Hi everybody, I'm going to give everyone a few minutes to log in from the waiting room. I do want to let you know that we have closed captioning. You should see it at the top left of your screen. There's a red live button, so you can click on that, and I'll also share the link to the closed captioning in the chat box in case you have trouble just clicking on the link. It does open in a separate screen, so I apologize, it won't be right on the screen. Here's the link for closed captioning. So welcome everybody. I'm Christy Bagalow, the Director of Statewide Training at Florida Legal Services, and we are back for the third and final installment of Tenants' Rights Tuesdays. I have not scared off Dr. Andrea and Suzanne. Thank you for coming back, ladies, to do a third one of these. They are my fair housing and landlord tenant champions for sure. So if you missed the other two installments of Tenants' Rights Tuesdays, you can find them on our YouTube page, which I will also put in the chat after we get started. So make sure you subscribe to that page, and that will allow you to see all the videos I've uploaded. And I've also been working on uploading closed captioning for all of the recorded videos. This is being recorded, and closed captioning is available in case you missed the announcement at the beginning. There's a red live button at the top of your screen. And I also put the link to the closed captioning in the chat box. And I'll put my email in there too in case you have any problems with closed captioning or anything else technology related as we go along. So I am delighted to have back with us again Suzanne Garrow. She's the coordinator of the Eviction Defense Self-Help Project and a staff attorney at Jacksonville Area Legal Aid. Welcome back, Suzanne. And we also have Dr. Andrea Mosley. She is the managing attorney of Fair Housing Programs at Community Legal Services of Mid-Florida. So I will go ahead and share my screen so we can get started with the webinar.
Okay, hello everyone, and welcome back or welcome for the first time. We are continuing the first part of our landlord-tenant overview, and we are starting with terminations of tenancy, I believe. So next page. Yes. So in chapter 83, which is basically landlord tenant, there are a few ways to terminate your tenancy with a 3-day notice, and that is for to pay or quit, right? So it says you owe X amount of dollars and you must pay or quit by this date. The 3 days that you get does not include holidays or Saturday and Sunday. Now the holidays have to be court holidays. And the way that, the court holidays is to go to the local county court where you live for your county, and they will have the court holidays there. The landlord, since the landlord is giving you a 3-day notice to pay or quit, they can't refuse rent during that time. So if you have the amount that they're asking for and you pay and you offer to pay, the landlord can't refuse to accept that because the notice says pay or quit. So, and the landlord may not file an eviction before those 3 days have passed. So if the landlord gave you 3 days and filed an eviction in 1 day, that's not proper. There's also another way of terminating your tenancy, and that is non-compliance. Now in today's environment with the moratorium, which Suzanne will talk about later, you will see more non-compliance or non-renewal type notices. So they serve a 7-day notice and you will have 7 days to correct. If the tenant hasn't complied after 7 days, the landlord can begin the eviction process based on non-compliance. If the issue is something that the tenant should not be given an opportunity to correct. damage, like you said, a fire, intentional misuse, something that put other tenants in danger. Or it is the second notice for the same issue within 12 months. So often you will notice that you get notices, successive notices, and you have no idea why. It is because eventually the landlord is going to move to evict you for non-compliance if they give you the same notice for the exact same behavior within 12 months. So rules vary in public and subsidized housing. So subsidized housing may have to give you even more notice than you would have to get if it was just a private landlord. So you have to know there's certain rules that apply with subsidized housing, which will give you more time, but it will in no way give you less. And you can request a reasonable accommodation if you receive a 7-day notice for non-compliance. So if you receive a 7-day notice for non-compliance and it's for you haven't been keeping up with the maintenance of the lawn, right? Or you have an animal on the property and it turns out it's your emotional support animal or service animal and you're not allowed to have pets, that type of thing. If it's related to your disability, you can't do a reasonable accommodation request. And then the third termination is end of lease. The lease ends and by its terms does not automatically renew and says that it does not automatically renew. And without a lease, either party can give written notice to the other of their intentions. So the amount of notice depends on the period for which the rent is payable. So if rent is paid weekly, you would get 7 days or 15 days or 30 days or 60 days, depending on how rent is paid. And all correspondence relating to your intention to terminate to the landlord is advisable to do by mail if you cannot safely hand deliver. And if you hand deliver, insist on a receipt. And that goes for anything. If you hand your landlord anything, insist on a receipt or acknowledgement that it was received, because that's how you prove it was delivered. And again, the rules vary when you're discussing public or subsidized housing. Next slide. So a holdover tenant is defined by statute as if a tenant holds over and continues in possession of the dwelling unit or any part thereafter the expiration of a rental agreement without the permission of the landlord. The landlord may recover possession of a dwelling unit in the manner prescribed by the statute. And the landlord may also recover double rent for the period that the tenant refuses to surrender possession. And that's Florida Statute 8358. It needs to be some kind of notice that you are a holdover tenant. You have to get notice that you're a holdover tenant and that they will be seeking double rent. Sometimes a lease will expire, but you just keep staying there and paying rent. That's not a holdover tenant. So they need to give you notice that you are a holdover tenant. Suzanne?
Next slide, please. We are going to talk today about the eviction process. And we've started already with the termination of tenancy. The only way that you can be ordered from your home in the state of Florida is if a judge orders you out and if the landlord has gone through an eviction process. The first part of the process is being served with a notice, either a 3-day notice that Andrea discussed, a 7-day notice, or a notice to vacate. Landlord has to then file a complaint for eviction with the court. So after the time lapses for the notice, that's when the landlord can file the complaint. After that time, you have to be served with the complaint. There's a service requirement What that means is that a process server or the sheriff will deliver the complaint to your home. They have to try to get it to you personally, but if they can't, by the second time they can post it. So you should also be receiving it in the mail from the clerk, but service is the key to beginning the response date. At that point, the tenant has 5 business days to respond. Same business days, no Saturday, no Sunday, no court holidays. They also, as a tenant, you have to deposit in non-pay cases the undisputed amount of rent into the court registry at the time you file your response. If you do not do both, then the landlord is going to win. It's what is called a default judgment. The law requires you to file a response and deposit undisputed rent. Again, if you don't do both, the landlord wins. It's a default judgment. Next slide, please. So there are a number of defenses to eviction. Generally speaking, though, the only defense to non-payment of rent is that you paid your rent or that you're lawfully withholding. But let me go through some of the distinctions that are out there, and also some of the current defenses related to COVID. So if you give a notice, you receive a 3-day notice and the landlord refuses to accept payment or refuses to accept payment when rent was due, that's a defense. If the landlord accepted all the payment in full, that's a defense. This all should drum up in your head that you should always be getting receipts. And as Andrea said, do everything in writing. So getting receipts is essential to prove that the landlord accepted rent. The landlord failed to provide a 3-day or 7-day notice. That is a defense. It's often not a winning defense, I will tell you, because judges hear all the time, I didn't get my notice. And so they take that with limited weight, but that is a defense. Landlord failed to repair pursuant to a proper 7-day notice. So I believe we talked last time about getting repairs done in your home. And so if you give a proper 7-day notice when you are current on your rent, typically that repairs need to be done to material conditions and they fail to do that, you could start to lawfully withhold your rent. And so when you lawfully withhold your rent and you can prove it because you have it all in writing, then that's a defense to the eviction. The landlord is requesting the wrong amount of rent too. That's, I guess, not technically a defense, but it is something you need to raise in your response in the form of what's called a motion to determine rent, which is part of the response. And we'll talk more about how you do that later on in this presentation. The landlord includes late fees that are not rent. Again, that's part of a motion to determine rent. If they're asking for $1,000, but your rent is only $700, you cannot be evicted for non-payment of fees. You could only be evicted for non-payment of rent, although there are occasionally provisions in leases that make fees into rent. A little technical, but if that happens, then you have to be careful and make sure if they're claiming fees that are not rent, that you file a motion to determine rent. Retaliation is a defense to eviction. So if you did certain prohibited or certain activities and your landlord that are set forth typically in the statute, if your landlord then tries to evict you, that's retaliation, that's a defense. Discrimination, including the failure to reasonably accommodate a disability, is a defense to eviction. There are also COVID-related protections in existence now. I think I'm going to hold off on those for now because we're going to talk about that more extensively later on in the presentation. But those are the defenses. Those are the only defenses, not defenses. Although again, this is with a star because of COVID changing this a little bit. Tenant loses their job or wages decrease. Another party to the lease did not pay. You expected on someone else to pay, but they didn't. You all owe on the same lease. The landlord failed to make repairs without tenant giving a proper 7-day notice. Very important. A lot of people think because they have repairs that need to be made and they stop paying their rent, that's legal. You have to give a lawful 7-day notice that is very specific in statute before you can withhold your rent. Lastly, medical emergency is not a defense to eviction. Next slide, please. Now, mobile home park evictions. Those are a little bit different in that they're governed by a statute 723. 723 sets out very specific standards and the law relating to mobile home park evictions. Non-payment of rent, the notice is a little different. You get a 5-day notice. You may pay the rental amount due, including any late charges, costs, and fees. And the court may, for good cause, deny the eviction if non-payment has not occurred more than twice. So you get a larger cure period and a bigger cure right. Conviction of a violation of a federal or state law or local ordinance. You can be evicted for that specifically if the violation is detrimental to health, safety, or welfare of other residents at the mobile home park, and you have a 7-day notice. You may be able to cure certain of these, but you get a 7-day notice. Violation of a park rule or regulation, the rental agreement, or this chapter, meaning 723. So for the first violation of any properly promulgated rule or regulation, rental agreement provision, or this chapter, which is found by any court of competent jurisdiction to have been an act that endangered life, health, safety, or propriety of park residents or employees, or peaceful enjoyment of the mobile home park by its residents. A second violation of the same properly promulgated rule or regulation within 12 months of the first violation. So you do get rights to cure, but by the second violation, there's a 30-day notice to vacate, and curing is no longer a defense. And change in land use of the mobile home park itself, you are entitled to and should get 6 months notice.
All right, I hope everyone is paying close attention. Fair warning, there is a poll coming up on the next slide. And if you're joining by phone, you may have to scroll down to the bottom of your phone to get the poll to show up. And I did want to mention that we're going to hold questions until the end, but you're free to type them into the Q&A box during the webinar. We're just going to hold it until the end to make sure we get through everything. So this poll is what Suzanne was just talking about, mobile home park eviction notices. So the choices are: all eviction notices must be A, taped to your door or posted; B, mailed certified or registered mail return receipt request; C, both; and D, none of the above. So I'm going to go ahead and launch that poll and give everyone a couple seconds to vote in it. Okay, it looks like we got quite a few votes. The winner so far is C, both. So what's the verdict, ladies?
Oh my goodness, you guys are too good. You guys don't need us anymore. Here, you guys have all the answers. Okay, that is correct. Especially if they're going to terminate your tenancy, they need to do both. And most people don't know that, including the mobile home park owners. All right, let me close that out. Okay, so going to court. Now, of course, with COVID, could be a bit different, but we're going to go into court. All hearings will be set by the court after the filing of the complaint and the answer. And as Suzanne said, if you get defaulted, no hearings. No date is set if the tenant does not answer the complaint and does not deposit the correct amount of money with the court, or if the landlord gets a default judgment. The parties will be notified of where and when the eviction hearing will take place. Both parties get to present their case before the judge. Now, assuming you've done everything you're supposed to do, both parties get a hearing before the judge. And it varies by county and by judge. And if you need a reasonable accommodation request based on the reason you're being evicted, you can file it at any time as long as you haven't been evicted by the court. So during the process of eviction, until the court makes a judgment, you can file for a reasonable accommodation at any time. Currently, evictions are being held telephonically or using Zoom. I will say some judges will automatically order everyone to mediation, some judges won't. So every procedure is different in every county.
And you see my picture again, so that means another poll is coming up. We're trying to keep you guys engaged today. So the next poll is about technology in these virtual hearings. So I'm going to go ahead and launch the poll while I read out the options. We'll go a little faster. And I promise I will share the YouTube link. It's just when I try to share something in chat, it messes up the PowerPoint. So I am trying very hard not to mess it up. So this poll is about technology for virtual eviction hearings, asking if you have a smartphone and enough internet or a data plan to join a hearing and make sure you don't get kicked off the hearing. So A is yes, I have a smartphone and enough data plan internet connection. B, yes, I have a home computer or laptop with a good internet connection. C, no, I only have a regular phone to call into a hearing. And D, no, I do not have a smartphone or home computer or laptop. So as Suzanne and Andrea will tell you, it varies court to court whether the judges will let you appear by phone or not. So that can be a big concern. So it looks like most people have voted, and most people say B, yes, they at least have a home computer, which may be a little easier to join a hearing on than a smartphone. I'm going to go and end the poll. I know one time I tried to have a meeting with a client via his smartphone, and it just kept rotating and rotating. I was like, I know he's not doing cartwheels, but the phone is.
Yeah. Now, it's important in, under these circumstances that you have some way to join, which we were fearful as tenant advocates that would be problematic. So it's great to hear that people do have connectivity and the ability to join even by Zoom, which is probably the best if the court is going to do that, because it's closer to in-person than just on a phone. So that's great.
And I would suggest trying out a Zoom call to your friend first, to just to make sure you can do it and you know how to do it. Because you don't want to try and do it the day of, because something will go wrong or something's not right. So just try ahead of time, just call somebody you miss and you haven't seen and say, I need to Zoom you real quick, check on you. So what if the landlord wins? If the landlord wins and gets a judgment for possession, the court will issue a final 24-hour notice. This notice is called a writ of possession. The sheriff then posts a notice on the tenant's rental home, and the tenant has 24 hours to move out. After 24 hours, the sheriff or the landlord can forcibly evict the tenant and padlock the door. This can be done with or without the tenant's belongings inside. The landlord may impose a lien on the belongings up to the amount of rent due, which is tricky business, but usually they just say it's all worth what you owe me. But if you get a writ of possession posted on your door, you can file a motion, but it's very unlikely that the eviction can be stopped at that.
And excuse me, I will say that there is a misconception out there perhaps that no writs of possession are issuing. That is a misconception. There are certain COVID-related protections that tenants may be entitled to, but not in all cases. So this is sort of the normal procedure, and there may be some defenses that you have that are COVID related, which we will discuss, but know that writs are still issuing in a number of cases.
Yep. Next slide for Suzanne.
So a mobile home eviction, what if the landlord wins there? That's a judge has to enter a judgment of possession. So they've gone through all the other steps, and the judge will enter the judgment. A writ of possession is issued. However, it is a 10-day window after judgment of possession, with the understanding that this is sort of a bigger endeavor, particularly if you own the mobile home itself. While many can't be moved, you know, it's still a bigger endeavor to have to move from a mobile home. So you have to remove all your possessions within the mobile home and your mobile home, if that's what you're going to be doing from the mobile home part. So whether you're vacating the mobile home itself or taking the mobile home, you have to do that. And then after, when the writ is executed on, the landlord's agent or the sheriff can remove any personal property. I'm sorry, the landlord or their agent, whoever that is, can remove any personal property, including the mobile home found on the premises, and to or near the property line. Or in the case of a mobile home, it could also be moved into storage. So that is the process if the landlord wins in a mobile home.
And most likely they just take over your mobile home if you don't take it.
Yep, that often happens, and they try and rent it out after that, rent it to somebody new.
They just take over it. So
illegal self-help evictions. So we call these evictions, but they're not. They're illegal actions, prohibited practices by the landlord to try and get you out without going through the lawful eviction process. Shutting off utilities to the rental unit, changing the locks on the doors. Sometimes some landlords will remove the doors or the windows or some part to force you out. Taking property from the home, preventing you access to the unit where you live. Again, these are called prohibited practices. They're in a statute, and the landlord, if they take these actions, could be responsible for paying the tenant damages worth to up to 3 times the monthly rent. So these are affirmative claims that a tenant has against the landlord if any of these actions occur.
Okay, that means we have another pop quiz coming up. So this is about those self-help illegal actions that Suzanne was just talking about. So let me launch that poll. So the choices are: the following self-help actions by the landlord is not prohibited or illegal. A, changing the locks. B, turning off the water. C, turning off the AC. D, none of the above. These are all illegal self-help actions. This is going to be a fun one. All right, so most people have voted. The majority said D, none of the above. These are all illegal. Next highest was turning off the air conditioning. So what's the verdict?
These are all illegal self-help actions under virtually every circumstance.
yeah. Remember, we talked about you don't have a right to AC, but if they are provided, they can't take it away.
Exactly.
So, guys who voted C were probably paying attention last time. So you're doing good, but if they provide it, they can't take it away. So just remember that. You guys are killing it.
That's for sure.
All right, is this me, Suzanne?
I think so.
All right, why not? Security deposits. Typically, you should be giving it at the beginning of your tenancy. And there really isn't any limit that I'm aware of security deposit in Florida. How about you, Suzanne?
No, if it's you contract for it, you pay it.
And the landlord must tell the tenant where the deposit is being held, which most times you guys don't have that conversation, but it's in statute. And at the end of the tenancy, the landlord must return the full amount of deposit within 15 days after the tenant leaves the dwelling, or gives the tenant written notice of why some or all of it won't be returned within 30 days after the tenant leaves the dwelling. And then the tenant has 15 days to object in writing once they receive the notice. So it's kind of confusing, right? They have to, if you don't get your security deposit back in 15 days, then that's your signal that they're probably trying to keep some. And you should be getting a notice by the end of 30 days of what they're trying to keep. Now, sometimes they do, sometimes they don't, but that's the statute. Even if you get evicted, you have a right to your security deposit back. People don't know that, but it's true.
And if the landlord doesn't provide you the proper written notice that they're withholding some or all of your deposit, the law says you should be getting it back, but you're going to have to sue your landlord for that in small claims. So.
And you need to give them a forwarding address. That's the trick of it all, right? They have to send notice to your last known address. So if your last known address is that place that you've been evicted from, I've seen forwarding of mail go horribly wrong. And you never get your forwarded mail, or it comes months and months later. So even if it has to be a PO box or something, give them an address in writing to send your security deposit back to. And that way they have to send it to your last known address. Do not depend on forwarding a mail, especially nowadays. You know, don't do it. Next slide. So what's trending now? So of course, COVID, but because of COVID, sexual harassment. So that's a violation of the Fair Housing Act, and that is where landlords are predatorily offering to exchange people who can't pay rent, reduce rent or no rent for some kind of sexual favor, for naked pictures, for whatever the case may be. Or they're making it a hostile environment because you turn them down or are not responding. Anything like that is sexual harassment and is prohibited. Prohibited practices. You won't leave, so they cut off your lights. They take out the AC. They lock you out of the apartment. That type of thing. That's prohibited practices. All the things we went through earlier with Suzanne. Domestic violence. I don't know if the trend is going down, but certainly when we were all in lockdown, domestic violence rose very high at that time. And then consumer issues. If you can't pay your rent, more often you have other issues, other bills you can't pay. And so all these things build upon each other. And so an option for those consumer issues most certainly is bankruptcy. And then probate, guardianship, wills, due to COVID. People, unfortunately, 190,000 people have passed away due to COVID. And people are sick in hospitals and can't respond. Or people are what they call now long haulers, who don't recover in the normal 14-day window, and they stay sick for an extra long time. They may at some point need a guardian. So these are all trends that we see are seeing due to COVID, and we want you to be aware of and keep an eye out, because sometimes you may have to be the person that kind of lets their neighbor know, hey, he can't do that, he shouldn't do that. And so, you know, if you attended this, give that person my number, Suzanne's number, so that they can get the help they need. Suzanne? Did you want to add anything?
No, I think those are the trends that we've been seeing, and particularly a lot of this due to COVID. So just, but Andrea makes a good point about, tell your neighbor if you see stuff going on. Also, there are two earlier presentations. The first part about getting repairs and other tenants' rights, and the last part and the first part about fair housing and some of these issues. So we urge you to take a look at those, because those will also give you some ideas of the trends and issues to be on the lookout for yourself and for your neighbors.
All right.
Next slide here.
So what's going on with the moratorium, Suzanne?
So the moratorium, there are a number of state and federal protections that may apply if your landlord is attempting to evict you at this time. I think, I'll say it again, there was a misconception out there that the governor's moratorium somehow prevented evictions for non-payment of rent from happening at all. That simply is not the case anymore. It has been now a couple months, and it will go through October 1st, the latest version of the governor's moratorium. So let me start there, which basically says that if you have a COVID-related loss of income that you can essentially show is COVID-related, then you can let the court know that, and the eviction can still continue on, but the writ or the final action, whatever that may be in your county court, will not happen. So the final piece of it will not happen until after the end of the moratorium, which right now expires October 1st. So really, you have to do everything we said today: answer the eviction, make your defenses, tell the court why the governor's moratorium applies, tell the court why the governor's moratorium may not require you to put all the rent in, because that's a typical requirement. So that's the governor's moratorium. I sort of started in the middle of the slide here, but also check your county. As I mentioned, your county might do it a little differently. Each judge within that county court might do it differently. So, but definitely look at what your county is doing in terms of final action and letting evictions proceed. There is also the Federal CARES Act, which essentially was valid and was active from mid-March through the end of July, and basically when there was a national emergency in effect, and until it sunsetted is what they say about federal laws. So if your landlord is looking for rent money, has brought a claim for non-payment of rent against you in court for rent money that was lost due to income that you lost in that time frame due to COVID, then you may have additional protections under the CARES Act. To be protected under the CARES Act, the most important thing you need to know is that your landlord has to be covered by the act. That means that it has to be either public housing or HUD or other tax credit housing, or your landlord has to have what's called a federally backed mortgage. It could be a private landlord, but that landlord has a Fannie Mae, a VHA, some sort of federally backed mortgage. Those three websites that we have listed under the CARES Act are all tools to find out whether your landlord is a covered landlord, affording you the protections of the CARES Act. And again, it means that the eviction case will go on, but you plead these CARES Act protections, and then the judge should follow those CARES Act and not let you be evicted as a result. The first website there is for if you're in public housing or you think you might have public housing, that's how you check. The others are to see if there are federally backed mortgages on your private landlord-tenant arrangement. Because sometimes you live in a place that receives tax credit properties, tax credits and things from HUD, but you wouldn't know it. So use those three to see if your landlord is a covered property. And if you don't know, then you'll say, I don't know, and you might want to claim it anyway and ask the court to ask the landlord whether they're CARES Act protected, because they would know best. Mm-hmm. Finally, for moratorium protection, the Centers for Disease Control on September 4th issued an order that basically says no evictions can happen if and only if the tenant meets certain very specific requirements. And one of those requirements is that they've completed a declaration, a signed statement under the pains and penalties of perjury, given it to their landlord, stating that they fit within the Centers for Disease Control moratorium requirements, and then presented it to their landlord. And then that is a defense, again, that you can claim if an eviction is brought against you. The requirements include things like trying to pay your rent and paying as much as possible. Mm-hmm. If you can pay some. There's also that you've sought outside governmental assistance to try and supplement your rent. So there are a number of requirements that you have to plead that you meet under the pains and penalties of perjury. Bottom line is, if you can fill out this declaration, then you should have protection from being evicted through December 31st, 2020. Again, the evictions might start, but in some counties, they're treating this as a defense. In other counties, they're treating this as a stay. In other counties, they're treating this as a reason to throw out the case until January 1st. So, but you have to use the tool, use the defense to be able to have any of these things apply to you. The last, www.floridaevictionhelp.org, the last link on here is an eviction defense form builder that Jacksonville Area Legal Aid and others created to create a response to eviction cases, eviction complaints against you that contain all these different moratoriums that we just discussed, that I just told you about, and it walks you through so you know what applies to you and what doesn't apply to you. It'll also link you to the CDC declaration that I just discussed. So we urge you that if you're facing eviction, to go to that website, floridaevictionhelp.org, and use it as a tool both to provide your response and to learn some of your rights. So you don't have to remember everything I just told you in your head. So that's it. These can be powerful defenses, so make sure you use them.
So Suzanne, would you put that as part of a defense or part of a motion to determine right?
Both.
Or anything applies? And
I think both, yeah. I think the key is to tell the court, I mean, that if you are trying to assert these protections, you have to tell the court. And I think you do it both in your response because it provides a defense, but very good point also in your motion to determine rent, because if you don't have the money to put into the registry, you could get defaulted unless you claim a reason why. And if the governor and the Centers for Disease Control are saying and recognizing that there may not be full payment, then it would be silly to require you to make full payment into the registry when you're trying to defend yourself in the eviction. So you definitely want to raise it under both the response as well as in the motion to determine rent.
And all those forms are in the form builder with Jala, right?
Yes, and it's a guided interactive interview that walks you through it. So it generates those forms at the end with those defenses.
Excellent.
Thank you for all that helpful information. What's the best way for people to reach your agencies if they need help? I put some resources in the chat box, but I just want to confirm with you all and have you read out the helpline number or the website, or what's the best way for people to contact you?
We have a lot of our contact online, particularly these days. I think that's probably the best way, and it's Jack's Legal Aid, JAXLEGALAID, all one word, .org.
We have the CLSMF helpline for Central Florida counties. It's 1-800-405-1417. And our website is clsmf.org. That's Community Legal Services Mid-Florida, the first letters for each word, .org. Again, 1-800-405-1417.
And when the webinar ends, it'll take you right to that form builder, which Suzanne helped create. I'm not going to let her be shy. So it's a great tool for everyone to use. And it's pretty easy to use. It's free for everyone.
And I guess I will also, I know everybody has smartphones and great connectivity, but our phone number, if you need to get through to us, is 904-356-8371. That's the main number. So they will direct you there. So, but either way.
When you call, ask for Suzanne and tell them Dr. Mosley sent you.
That's right. So we do have time for questions, and I did see a couple come through. So, and I'll try to put some more resources in the chat box now that we're done with the PowerPoint, and I hopefully won't mess anything up and end the webinar in the middle of a question. Okay, so the first question is, if the tenant is affected by COVID, do they still have to pay late fees?
That's a very good question. If they're CARES Act protected, late fees were forgiven during that particular time frame, and they should not be evicted for late fees.
Okay, that was easy. The next one is, if a lease expires and the tenant lost their job due to COVID and is unable to move due to financial hardship, the rent is paid up to the date, I assume, when the tenant lost their job. Can this tenant be served with an eviction?
That's a very good question. We believe that there is CDC, that the CDC declaration, the CDC order would provide them some assistance, but you'd have to be covered by that. And that, let me just say one more thing about the CDC order. The loss of income does not have to be COVID related. That's a separate, that is a concern by the CDC of people being homeless and living in too close quarters with other friends and family if they're evicted. So in that case, it could be fine, but the non-renewal of a lease typically is one of the reasons why you could potentially be evicted under certain circumstances in this regime.
Okay.
You could, but the hope is that the writ won't be executed basically to avoid the COVID. So be prepared for that. But yeah, there's very few solid answers around this time, but
Things change daily. Okay, the next one is, does the notice to withhold have to be sent via certified mail?
No.
Okay.
In fact, I say don't, but I've learned from my colleague, Dr. Mosley, that as long as there's no return receipt requested, you can still track it and know that it got delivered, but you don't want a return receipt. Am I right? Because then they can refuse it. So
return receipt is the green card, and That's what you don't need. So certified mail return receipt, you could just send it certified mail. And that's a definite way of tracking.
I prefer hand delivery myself with the client bringing a witness or getting a receipt if their landlord will write on it, because then the 7 days start to run. That's what I always tell my clients to do.
That's the
Text
fast.
it, email it, hand deliver it.
However you guys typically communicate now, I think is a valid argument, because because of COVID, you can't go into the office. A lot of people aren't allowed into the office because of COVID. So however you are typically communicating with your landlord, if it's email, if it's text, give them the notice, because that's your manner of communicating now.
That's not what I expected. I just assumed, I think a lot of people assume that certified mail return receipt requested is the only official way to do things. So I'm glad you gave all those suggestions. There was just an update to that previous question that the person was up to date on rent, just doesn't have the money to move. So again, it could vary depending on which jurisdiction, whether the eviction will be filed or stayed, or if the evictions won't be served. And we do have another question. Let me find it over in the chat. There may be other questions hiding over there. And I did put in the Florida Legal Services YouTube page link, so please subscribe to that. That has all the previous webinars with our superstars, Suzanne and Andrea, and other subjects in case you ever get tired of housing and fair housing landlord tenant, which I just can't imagine, but just in case that happens. So the next question is, which process applies, mobile home or residential eviction process, when an individual rents a mobile home from the mobile home owner? Also, must a tenant be current to serve a 7-day notice to withhold for failure to repair?
It's Chapter 83 if you rent the mobile home, and it's the mobile home statute if you own the mobile home and rent the lot.
Okay. And then the second part, do they have to be current on rent to serve a 7-day notice to withhold for failure to repair?
It's best practices is to be current on your rent. There is nothing in the statute that says that. There is some loan authority in Southern Florida that supports that you don't have to be current, but I do believe it's best practices. And we always advise clients that way.
Yeah, it's best practices to be current, but I'm wondering, Suzanne, if in this environment, when because of COVID, you can't pay your rent, but something needs to be repaired and the landlord is refusing to repair.
Yeah, no, I think there's a little potentially less risk if you've lost your income due to COVID and they're not repairing and you need to send a 7-day notice. It's not in the statute, so that's a very good point. And so if you, you don't have zero rights if you're not getting, you don't have all your money, you're not able to pay all your rent. You don't have zero rights. So it's a very good, good point in this regime.
Okay. And that person said, thank you for all your answers. They are greatly appreciated. And I'm typing in right now while we give everyone one more minute to see if there's any more questions coming in. I'm typing in that we're having our next public webinar. Suzanne and Andrea get to take a break. This one will be Laura Sanchez from Legal Aid of the Orange County Bar Association in Orlando, and she'll be presenting about sealing and expunging criminal records in Florida. And that will be October 6th at 4 p.m. So I'm going to put the link in here. It's another one where you don't have to register. You can just join, and please share with anyone who might be able to use that information. And let me see if any more questions came in. Okay, that looks like it. Well, if we don't have any more questions, thank you so much, Suzanne and Andrea. Any last thoughts before we go? You let everyone out of class early. Thank you for doing this again. Take care, everybody.
My pleasure.
Bye-bye.
It's been a pleasure. Bye-bye.